Good afternoon, everyone. Thank you for being here. My name's Jason Kahns, and I'm a member of the Anthropology Department here at the University of Texas. We appreciate you making time to join us here on Monday evening for what I think will be a really interesting and exciting discussion. I'd like to begin with a land acknowledgement. We'd like to acknowledge that we're meeting on the indigenous lands of Turtle Island, the ancestral home of what is now called North America. Moreover, we would like to acknowledge the Alabama Coshada, Caddo, Caddo Carrizo, Comecrudo, Coahuiltecan, Comanche, Kickapoo, Lipan Apache, Tonkawa, Isleta del Sur Pueblo, and all the American Indian and indigenous peoples and communities who have been brought or have become part of the lands and territories in Texas. This talk is part of a colloquium being held this semester here at the Rapoport Center titled Cultures of Environmental Justice. The colloquium is meant to engage the different ways that environmental justice is understood, experienced, and lived in diverse contexts, and to open questions about the complex relationships between detection, action, and repair that thinking through and with environmental justice movements demands. Our next event in this series will be on February 27th at the same time and in the same place. It'll be a talk by Dr. Shafkat Hussain, the George and Martha Kellner Chair of South Asian Studies at Trinity College, titled The Snow Leopard and the Goat, Politics of Conservation in the Western Himalayas. You are all cordially invited to attend. I wish to start by thanking the Rapoport Center, and especially its directors, Karen Engel and Neville Hode, for making this series possible. I wish also to thank the Colloquium Series co-sponsors, Planet Texas 2050, the LBJ School of Public Affairs, the South Asia Institute, Native American and Indigenous Studies, the Teresa Lozano Long Institute of Latin American Studies, and the Departments of Geography, Anthropology, and City and Regional Planning. So we're privileged tonight to be joined by Dr. Julia Dehm. Dr. Dehm is a senior lecturer at Trobe Law School. Her scholarship addresses urgent issues of international and domestic climate change and environmental law, natural resource governments, and questions of human rights, economic inequality, and social justice. Her detailed analysis of various facets of international climate regimes coalesce to produce a compelling account of how the field of international environmental law is both structured by unequal power relations and complicit in their reproduction, and how international law is implicated in the production of ecological harm. Dr. Dehm's first monograph, Reconsidering REDD+, Authority, Power, and Law in the Green Economy, published by Cambridge University Press in 2021, was awarded the 2021 ECR Publication Prize from the Law and Society Association of Australia and New Zealand. She is formerly the co-editor-in-chief of the Journal of Human Rights and the Environment. During 2023, currently, she is a member of the School of Social Sciences at the Institute for Advanced Studies at Princeton University. Dr. Dehm is also a former postgraduate fellow here at the Rapoport Center when many of us first got to know her, and as an incisive scholar, fantastic colleague and friend. So it's a pleasure to welcome you back to Texas. Following Dr. Dehm's talk, Following Dr. Dehm's talk, Dr. Cooper Christensen will offer a brief response. Dr. Christensen is a current postgraduate fellow at the Rapoport Center, where he works on projects relating to the center's key human rights priorities. He joins us here at the Rapoport Center from the Promise Institute for Human Rights at the UCLA School of Law, where he served as the research and advocacy advisor to the UN Special Rapporteur on Contemporary Forms of Racism. His professional expertise includes international human rights law, particularly international legal obligations related to racial equality and non-discrimination and sexual orientation, as well as gender identity and expression and sex characteristics. There's a long acronym there.
It's a UN acronym.
I see. He graduated from the University of Minnesota Law School in 2021 with concentrations in both human rights and international law. So I think we're in for an exciting discussion this evening. So without further ado, please join me in welcoming Dr. Julia Dehm.
Great. Well, thank you so much, and thank you for the invitation to come and speak to you all today. I'm delighted to be here, particularly after having so many fond memories of being at the Rapoport Center in 2015 to 2017. And I was very privileged to audit one of Jason's classes also during my time here. And so I'm really delighted to be able to contribute towards this, these ongoing discussions on cultures of environmental justice. I also want to acknowledge the traditional owners of the land on which we're meeting and pay my respects to their elders past and present. And specifically, I want to emphasise that I think it's really important when we're meeting in a law school, as we are today, that's concerned with lawful relations, to acknowledge that there are other laws in this place other than the settler colonial legal system. And moreover, particularly when we're talking about questions of climate justice and environmental justice, to recognise the importance of Indigenous knowledge systems, of leadership and obligations to country in working towards ecologically just futures. So in my talk today, I want to discuss some of the ways in which the demand for reparations or compensatory justice for historical emissions have been resisted, evaded and avoided within the international climate regime, and to use this to think more broadly about some of the structural limitations of international law in enabling reparatory climate justice and how this could be contested. Before addressing the question of how compensation for historical emissions has been resisted, evaded and avoided within the international climate regime, I think it's helpful to outline why it is that historical emissions matter and why it is that they give rise to claims for compensation or reparation. So to do so, I'll just quickly play this video, which gives you a sense of what countries are responsible for historical emissions. You can see there that sort of tracking over time in that video. This has been put together by the Carbon Brief newsletter. So we know that during the period of 1850 to 2002, industrialised countries were responsible for 3 times the carbon dioxide emissions of developing countries. The United States is responsible for 20% of total cumulative carbon dioxide emissions, the European Union for 17%. At present, developing countries account for the majority of current emissions, but it must be kept in mind that those countries are much larger in population numbers, home to a larger proportion of the global population, and that emissions are distributed unequally between them. So I'm sure we've all seen the graphs of the vast inequalities in global emissions, both between and within countries, and increasingly sort of getting graphs about the differences between different people in the world and the oversized impact that a transnational elite has. So a recent study, for example, quantified each country's share of responsibility for global emissions in excess of a planetary boundary of 350 parts per million. We're currently at 417, so well past that boundary, and found that countries of the global north were collectively responsible for 92% of these excessive emissions. Other studies have shown that just 90 companies, the so-called carbon majors, are responsible for 2/3 of global emissions since the Industrial Revolution. And we can look at these sort of infographics to get their names and addresses, so to speak. Yet it is the people of the global south and Indigenous communities who are already most economically and socially marginalised that will bear the worst impacts of climate change. Vulnerabilities to climate impacts are driven by drivers of inequality such as gender, race, ethnic origin, age, level of ability, sexuality and diverse gender orientations. Already 5 million deaths per year are linked to climate change, and climate disasters are costing over 100 billion annually, and these figures are projected to increase as climate change intensifies. Some estimates suggest that developing countries will face between 290 billion and 580 billion economic losses from climate change in 2030, in addition to non-economic losses, with some predictions suggesting that losses could reach 1.7 trillion by 2050. So having sort of mapped out these sort of vast inequalities in historical emissions, I want to ask the question of why do these historical emissions matter? And I think there's a couple of different answers we can give to this question. So firstly, we could say that historical emissions matter because they have caused serious harms. So recent development in extreme event attribution science allows scientists to draw closer connections between certain emissions and their effects in the world. And the cumulative emissions of the United States, the European Union, Russia, Japan and Canada between 1850 and 2012 will contribute to nearly half a degree Celsius of temperature increase by 2100. So we can measure these sort of direct impacts that these emissions are having in the world. Another argument that's commonly used by developing countries about why these historical emissions matter is that the excessive historical emissions of industrialised states in the global north have appropriated atmospheric space and thereby prevent other countries from emitting their fair share within a carbon budget consistent with the global temperature target of remaining below 2 degrees of warming. So therefore, other countries are prevented from following the same sort of development trajectories that the industrialised countries of the global north have followed and have become rich by pursuing. However, the response to this question that Sarah Rowling Case and I provide in a chapter that we recently wrote on historical emissions is that responsibility for historical emissions arises not simply because industrialised states in the global north have appropriated atmospheric space, but because these acts were constitutive in enabling the conditions for dispossession, for violence, slavery, racial difference and uneven well-being that generated and continues to generate stark asymmetries between and within countries. So these historical emissions, we argue, are not harmful just in and of themselves, but because these emissions have enabled certain actions and certain legal relationships that have ongoing effects. So what we're trying to show with this argument is that colonialism, capitalism and catastrophic climate change are structurally and not just contingently linked. And there's a growing body of scholarship that highlights, as Gurminder Barma and Peter Newell recently wrote, that, and I quote, the inequalities generated and exacerbated by climate change in the present have longer and connected histories once colonialism is properly acknowledged as a continuous factor. And even the Intergovernmental Panel on Climate Change, the most authoritative scientific body on climate change, in its last assessment report, acknowledged the link between climate change and colonialism. So if we accept that these emissions matter, that they have caused harm, that they've denied opportunities and produced a violent, exclusionary and hierarchical ordered global political economy, what obligations do or should they give rise to? In his recent book, Rethinking Reparations, political philosopher Ofemi Taiwo makes his case for reparations as a construction project. That is, in order to contend with the immense scale of injustice, he argues, requires thinking more broadly about how to remake the world system. So he contrasts and distinguishes his approach to reparations with two other approaches to reparations, one which he calls harm repair and relationship repair. The former approach, harm repair, is concerned with present harms and how they're causally connected to or constituted by past harms, and thereby putting those who have suffered and continue to suffer the impacts of past injustice in the position that they'd be in but for those historical harms. However, as Taiwo shows, this approach assumes a sort of accounting for and quantification of historical harms that is reductive. And even more problematically, it presupposes that it's possible to construct a counterfactual baseline of a world in which these harms did not occur. Moreover, this focus on the harms fails to appreciate how others have benefited precisely from these historical harms, and that the task of reparations need to grapple with both how historical injustices have produced structural harms for some, but also structural advantages for others. The relationship approach, in contrast, focuses on fixing damaged relationships between an aggrieved party and aggrieving parties and their inheritance, and addressing, including through community forms of repair such as apologies or commitments of non-repetition, the moral harm that has been done. So against these two approaches, Taiwo's preferred view is focused on building a just world and addressing how the benefits and burdens of any such transitional process are distributed. It is thus less focused on these questions of harm, on responsibility or liability, than on how we get to a position of social justice and how historically informed distributive justice informs the process towards that vision. So the argument that we've made that historical emissions matter, not just in themselves, but because these emissions enable certain actions and certain legal relationships and have constructed the world in a particular way and produced these stark global asymmetries of power and wealth, has close affinities with the constructive view of reparations that Taiwo advocates for. And as such, I think it suggests a way of thinking expansively about what climate reparations as a world-making project of building an ecologically just world in a way that is attentive to the structural inequalities that have been produced by fossil capitalism. I suggest it is also this view of reparations that underpins the recommendations made in the recent report that Cooper worked on, also by the former UN Special Rapporteur on Contemporary Forms of Racism, Tendai Chiume, on ecological crisis, climate justice and racial justice. In the recommendations in that report, she calls on the international community to prioritise reparations for historical, environmental and climate harms and for contemporary harms rooted in historical injustice. She argues that reparations require addressing historic climate injustice, as well as eradicating contemporary systemic racism that is a legacy of historic injustice in the context of the global ecological crisis. More radically, even, she argues that, and I quote, "To the extent that contemporary international legal principles present barriers to the historical responsibility for climate change, United Nations member states must decolonise or transform this law in a manner that makes it capable of guaranteeing genuine equality and self-determinations for all peoples." So this analysis and these recommendations, I think, leave open many difficult and provocative questions about what climate reparations as a constructive project directed to remaking the world might concretely or materially look like, as well as what it means to decolonise international law and what that entails. So in this talk, I want to talk about the ways in which international law has resisted calls for compensation for historical emissions as a way of starting to think through how we might need to unmake or remake international law in order to enable more ecologically just and reparative futures. Although the word reparations is now occasionally heard in climate law spaces, for a long time it was relatively taboo. For example, when Todd Stern, who was the US climate envoy to Barack Obama, was asked, "Do you believe in paying reparations to developing countries?" his immediate response was, "No, absolutely not. But I certainly believe in significant support for developing countries." A long-term participant in climate negotiations described reparations as a toxic term, and some liberal climate justice advocates refuse to use the term reparations, compensation or liability, believing them to be barriers within the negotiation. A critical look at the international climate negotiations shows how within the international climate regime, this demand for reparative justice has been persistently evaded due to developed countries' refusal to discuss compensation or historical harm or anything that might give rise to liability. The Alliance of Small Island States has been raising the issue of compensation for climate change since at least 1991, before the United Nations Framework Convention on Climate Change came into effect in 1992, so during the process of the drafting of this Framework Convention. When these questions were eventually taken up, they were then taken up within the climate regime under the agenda of loss and damage, where loss and damage refers to the impacts from climate change that has not been mitigated against or adapted to, and includes both the increased frequency and severity of extreme weather events, but also slow onset events such as sea level rise, increasing temperatures, ocean acidification, glacial retreat and related impacts, salinification, land and forest degradation, loss of biodiversity and desertification that are often much harder to sort of depict or represent or even make visible as forms of violence. The issue of loss and damage did not appear in the UN work programme until 15 years after the negotiation of the UNFCCC. And then when it did, it was included under enhanced adaptation actions as part of the 2007 Bali Action Plan. In 2013, in the wake of Typhoon Haiyan in the Philippines, in a major breakthrough, there was an agreement to establish the Warsaw International Mechanism for Loss and Damage Associated with Climate Change Impacts. The Warsaw International Mechanism has three core functions: enhancing an understanding of approaches to address loss and damage, strengthening dialogue coherence, coordination and synergies between relevant stakeholders, and enhancing action and support to address loss and damage in vulnerable developing countries. So the treatment of loss and damage was one of the controversial aspects of the 2015 Paris outcome. So Article 8 of the Paris Agreement recognises the importance of averting, minimising and addressing loss and damage associated with the adverse effects of climate change, including extreme weather events and slow onset events, and the role of sustainable development in reducing the risk of loss and damage. Sorry, that was a long quote from the treaty, a lot of UN language. However, the accompanying decision by the Conference of the Parties included a clause that you'll see right there at the bottom, that Article 8 of the Paris Agreement does not involve or provide any basis for liability or compensation. No new institutional mechanism was established, but the existing Warsaw International Mechanism was anchored into the Paris Agreement and subject to the authority of the Conference of the Parties. So while simply having loss and damage included as a third pillar in the Paris Agreement was a major victory for developing country states that had pushed for this to occur, much of the Warsaw International Mechanism's work plans have really focused on enhancing cooperation and facilitation, non-economic loss, increasing understanding of human mobility in the face of climate impacts, comprehensive risk management approaches and action to support finance, technology and capacity building. But there's been really little in way of particularly clear financing flowing to developing countries that are facing these impacts from climate change. In the aftermath of Paris, there have been a number of dialogues to try and progress these discussions on loss and damage. The SUVA expert dialogue in 2018 and 19, and in 2019 there was the establishment of the Santiago Network to catalyse technological assistance on loss and damage. In the last days of COP26 in Glasgow in 2021, China and the G77 launched a proposal for a Glasgow loss and damage facility to provide finance to vulnerable countries. However, this proposal was then not taken up and included. So you see a lot of talk, a lot of discussion, but very little by way of financial support and action until very recently. So due to massive civil society pressure, in a landmark decision at COP27 in Sharm el-Sheikh, Egypt, last year, the Conference of the Parties established for the first time a funding mechanism for loss and damage. However, I think it's crucial to recognise it did not establish any obligations for countries to actually contribute funds to it. So I've got the text of the decision there. You can see that they decided to establish new funding arrangements and decided to establish a new fund. They also established a transitional committee to make recommendations for the next COP meeting. There's a lot of talk fest that goes on in these spaces. That should have 10 members from developed countries and 14 from developing country parties. And this list of nominated members, I think, shows us a little bit about the lack of engagement with these sort of processes, that developed countries have yet to even nominate people to be on this committee. And so while I don't want to presuppose or preempt what the work of the committee will be or the outcome of the next COP, I think we're seeing here the same sort of stalling techniques that we've seen for a very long time, that even as the conversation moves forward, it does so in a way that's constantly being resisted and evaded and slowed down in particular ways. And my previous research has really focused on the fact that even when discussions finally do address this fraught issue of financing, the focus under these mechanisms has been on market-based private sector instruments, including weather-based index insurance schemes and catastrophe bonds. And so in a previous piece I think some of you have been subjected to reading, I argued that the promotion of these responses to loss and damage are orientated towards a responsibilisation of the vulnerable and risk-exposed subject, even as they obscure the responsibility of historical polluters who have contributed most to changing the climate. So through these processes of prudential risk management, insurance and financialisation, countries of the Global South are being required to take responsibility for their own vulnerability and to mediate this through engagement with financialised markets. And I argue that these approaches thus locate responsibility to manage risks with the vulnerable nations of the Global South, rather than impose responsibility and accountability on the countries and corporations most responsible for causing the climate crisis. So at COP27 last year, arguably in order to preempt civil society pressure to establish a loss and damage fund, the European Union came to the negotiations with a proposal to launch a global shield insurance initiative that was promoted as helping low-income and vulnerable countries to rebound after extreme climate events by strengthening social protection schemes and fostering climate risk insurance. So Germany, for example, had pledged $172 million to help establish the initiative, and Canada, Ireland and Denmark have also pledged a further €40 million. And while such approaches are certainly better than nothing, climate justice advocates have critiqued such initiatives, arguing that there are clear limitations to insurance-based initiatives, especially as places increasingly become uninsurable due to worsening extreme weather and multiplying disasters. Harjeet Singh from the Climate Action Network argued that the details on such schemes are very vague and very opaque, and that insurance mechanisms don't cover climate-induced slow onset events, that insurance schemes that pay too little in the event of disaster and isn't sufficient to mobilise the vast sums of money that are needed, given that these estimates could run into trillions of dollars, as I outlined earlier. More recently, Johnson et al. Have suggested that there's an emerging governmentality of loss and damage, and shown how, in the way in which loss and damage initiatives are being implemented on the ground, the causes of climate harms are being obscured, Western knowledge and technocratic interventions are centred in responses, and certain colonial subjectivities are imposed on those impacted by climate change in the global south. However, they're optimistic that it's still possible for loss and damage to, and I quote, avoid the same fate of mitigation and adaptation which has been captured by dominant neoliberal climate governmentality. However, this would require, they argue, the emerging loss and damage, that the emerging loss and damage governmentality, with its obstruction, colonial knowledge claims and presupposed subjectivities, be confronted and shifted. And in closing, they remind us that loss and damage is fundamentally about addressing colonial capital climate harms to the human and more than human worlds, and that the truly radical potential of loss and damage is implicit, but needs to be developed further to be made explicit. So given these limitations of the discussions within the international climate regime, it's not surprising that climate justice activists and communities who are suffering the impacts of climate change are looking for legal avenues for redress outside the climate regime. There's been a rapid growth in climate litigation, defined by the United Nations Environment Programme as cases brought before administrative, judicial and other investigatory bodies that raise issues of law or fact regarding the science of climate change and climate change mitigation and adaptation efforts. The number of climate change-related cases has more than doubled since 2015, so while we had just 800 cases between 1986 and 2014, we've had over 1,000 cases brought between 2015 and 2021. And we're now seeing this sort of climate litigation in jurisdictions around the world, initially more in the global north, with the most cases in the US and Australia, but increasingly cases in countries all around the global south as well as before various international and regional courts, human rights mechanisms and other tribunals. And these cases, which initially focused on traditional environmental law arguments such as administrative appeals against approvals of coal mines and other related fossil fuel infrastructures, have expanded in scope and are mobilising new and novel legal arguments, including around corporate risk disclosure, obligations, fiduciary obligations of trustees to beneficiaries in the context of super funds, and there's also been a rights turn in climate litigation, so the drawing of human rights arguments in these cases. So some of the climate litigation databases now list 118 different cases concerning climate change and human rights. So some of the most prominent is a petition that was filed before the Philippine Commission on Human Rights, focused on the responsibilities of the so-called carbon majors, those 90 companies responsible for 60% of global emissions I mentioned earlier, for existing climate impacts. And there's also an increasing number of tort-based claims seeking compensation from fossil fuel companies for the climate impacts that are being experienced by communities and individuals, including, for example, the transnational tort case brought by a farmer in Peru against the German energy giant RWE in Germany. One particular interesting development is the number of requests for advisory opinions that have been issued just in the last couple of months. So Vanuatu is currently pursuing efforts to seek an advisory opinion on climate change from the International Court of Justice. And I'm going to focus most of my comments on that, but I also want to note that there's two other advisory opinion requests currently pending, one to the Tribunal on the Law of the Sea and another to the Inter-American Court of Human Rights. So in contrast to a contentious case brought by one state party against another in relation to a specific dispute, an advisory opinion of the International Court of Justice is a non-binding interpretation of the law on a specific topic. So although they don't have binding force, such opinions carry legal weight and moral authority. And so, according to the UN Charter, an advisory opinion can be requested by the General Assembly or the Security Council or other organs of the United Nations or specialised agencies. And so I think it's very likely that we'll see a vote of the General Assembly in the next year requesting such an advisory opinion. And so on November 29th last year, they put forward this draft question, which has since been redrafted and reformulated slightly, that they'd want to put to the court to get a legal opinion on, or legal interpretation of. And the proposed questions, you can see that the first part of the question is focused on future-orientated obligations to protect the climate system for present and future generations. However, the second part of the question also asks about the legal consequences arising from acts or omissions that have caused significant harm to the environment, and thus it could open up discussions about liability for historical omissions. And the generally applicable legal principles that would apply, I think, in my interpretation anyway, and the arguments that Sarah Riley-Case and I have put forward in a chapter that we wrote too, are relatively established and straightforward. So the rule that applies is the no harm rule in international law. It's a general rule of international law, and that applies despite the existence of a specialised climate regime. The no harm rule provides that a state is responsible when it fails to take appropriate steps to prevent significant harm to other states or the global environment, and that there is both a duty to prevent this sort of transboundary harm to another state and a duty to prevent harm to areas beyond national jurisdiction, that is, to the climate per se or to humankind as a whole. The obligations imposed by the no harm rule are obligations of conduct, not of result. That is, that states are subject to an obligation to make their best efforts to prevent harm by exercising due diligence, but are not subject to an obligation to guarantee certain results. So we'd have to ask, what does exercising due diligence mean in this context? Due diligence involves both negative obligations, namely to refrain from transboundary interference, as well as positive obligations to evaluate and minimise the risk of harm. Due diligence is an adaptable standard, so what is required varies according to the risks and harm, context and circumstances. But basically it is in the legal tests, and I quote, conduct that can be expected of a good functioning government. Thus, like any legal test, there's a certain degree of flexibility or subjectivity in how it's applied. In our chapter, we argued that, quote, given that climate change entails damage of existential importance that threatens our very survival of humankind, the standard of conduct in preventing climate change must be of the highest stringency. But we'll see whether the ICJ takes a similar approach. And so a further factors that are relevant for determining the standard of due diligence is a state's capacity to address the risk of harm, which raises a number of further considerations, namely the opportunity to act or prevent harm, the foreseeability or knowledge of the risk of harm, and the proportionality in the choice of measures to address the harm. And again, we suggest in our analysis that these factors are satisfied, and thus under international law, states could be found to have breached the no harm rule. However, on this sort of pragmatic register, as advocates, we want to sort of push international law to recognise these sort of harms. As critical legal scholars, we also take a step back and say that there are real limitations in the sort of justice that this no harm rule can actually deliver in practice, that there are real barriers in getting historical responsibility for climate change, and these barriers are reproduced in the rule itself. So I'd argue on a more critical register that the current state of customary international law cannot fully address all the past and ongoing harms caused by historical emissions. One problem is the challenge in drawing specific lines of causation between historical emissions and present-day harms. And even though we've got the science of event attribution increasingly getting more sophisticated, drawing these lines of causation is still incredibly challenging. And then even if these forms of technocratic proof make it possible to draw these lines of causation, the no harm rule would ignore the ways in which emissions are embedded in, reflect and reproduce specific social relations. So returning to Tao's terminology, it could best provide for harm repair approach to reparations rather than this sort of more constructive world-making approach to reparations. Yet we also show how the operations of the law place real limits on what harms can actually be redressed. The intertemporal principle limits state responsibility to those acts that were internationally wrongful at the time they were committed. Thus, international law could best provide a remedy for greenhouse pollutants emitted after there was a specific consensus about the dangers of climate change, and it was foreseeable that the excessive emissions would cause harm to other states and other areas beyond national jurisdiction. And so, in our chapter, we argue that the fact that claims for historical responsibility based on the no harm rule might struggle to demonstrate all these elements and evidentiary requirements that the law demands does not indicate an inherent weakness in these claims. Rather, it should be seen as indicative of how these doctrines of international law are themselves inadequate to remedy the complex harms arising from historical omissions. So, in the remainder of the talk, I want to think a bit more about why international law is structurally inadequate for remedying these types of harms. So the limitations of international law in providing a remedy for historical harms has been highlighted by post-colonial legal scholars who have identified the ways in which international law has developed many mechanisms to prevent claims for colonial reparation. Oops, got my slides mixed up, sorry. The impetus behind Tony Angie's groundbreaking book, Sovereignty, Imperialism and the Making of International Law, was his work on the Nauru Commission that prepared the legal arguments for Nauru's ICJ case against Australia for environmental harms caused by resource extraction while Nauru was under colonial administration. So the question he had going into this research project was, why is it so hard to get compensation for these colonial harms? And the answer that his investigation revealed, I think, is really sort of shifted the whole field of international law on its head in a way, because he argued that colonialism was central to the constitution of international law in that many of the basic doctrines of international law, including most importantly sovereignty doctrine, were forged out of an attempt to create a legal system that could account for relations between the European and non-European worlds in the colonial confrontation. So his analysis, I suggest, raises really complex questions about the implications of recognising that existing legal doctrines, institutions, notions of rights, and perhaps even our conceptualisations of justice themselves are the product of precisely the violent history that demands repair. For now, I want to bracket the complex discussions that arise when we think about sovereignty and the metaphysics that it engages, and think some time about the effect that narratives of progress and our understandings of property rights have in making this challenge of realising reparations for historical harms. So critical international legal scholars have highlighted how accounts of progress are produced in and reproduced through international legal discourses. Thomas Sakaris, for example, has shown how international legal discourses have been structured by narratives of international law as progress, narratives of the development of law as a progressive force in the world, as well as narratives of continuous progress within international law. Although these narratives of progress are compellingly seductive, precisely because of how, I'd argue, they shore up and maintain faith in the promise of universal justice that lies at the heart of the project of international law, they can also be really dangerous, especially in the climate context. And my specific concern when thinking about this no harm rule is how these narratives of progress in and through international law risk closing down the gap that is necessary to keep prizing open in order for the operation of the no harm rule to even deliver some form of limited reparative justice. And these are a temporal gap between the time that knowledge of the harm from climate change was foreseeable and when the international community took action, as well as an ambition gap between what constitutes due diligence or the conduct that could be expected of a good and functioning government in the face of the climate crisis and what the action that was taken by the international community was. So narratives are the way in which we create meaning out of facts or events. They organise facts into events and events into stories and allow us to draw lines of causation between different facts and different events. More than that, in the process of creating a narrative, there's always a process of selection or organising facts or events into narratives. Some are relevant and some are not, and some are excluded. So, for example, in this essay, environmental historian William Croonan argues that in the act of separating story from non-story, we wield the most powerful yet dangerous tool of the narrative form. It is commonplace in modern literary theory that the very authority with which narrative presents its vision of reality is achieved by obscuring large proportions of that reality. Narrative succeeds to the extent that it hides the discommunities, ellipses, and contrary experiences that would undermine the intended meaning of the story. Whatever its overt purpose, it cannot avoid a covert exercise of power. It inevitably sanctions some voices while silencing others. Due to the work of investigative journalists and the uncovering of corporate archives by academics, there is increased evidence that fossil fuel companies and state actors had detailed and accurate scientific knowledge of climate change well before there was widespread public awareness or concern about climate change, and that many fossil fuel companies, rather than raising this awareness or taking actions, engaged in deliberate and targeted campaigns of misinformation to promote inaction or delay. Yet the story generally told in international legal accounts is not one of misinformation and deception. Rather, it's one of the gradual development of scientific knowledge over time, the growing political recognition of the need to develop an internationally authoritative account of the problem, which then led to the establishment of the Intergovernmental Panel on Climate Change in 1998. That was tasked with preparing a comprehensive review and recommendations with respect to the state of knowledge. And then we had the publication of their first assessment report in 1990, which then allowed for this consolidation of science and the negotiations which led to the UNFCCC in 1992. So we can see how in this account there's sort of a real progressive thrust that knowledge leads to legal action. This is repeated in other accounts. So Fleur Jones, for example, has shown how the work of the IPCC appears in international legal scholarship as a supralegal precipitance of legal action, as supralegal sources of evidence, or expression of some supralegal consensual community, and specifically how it's treated as this galvanising force that leads to legal collective action. So thus we can see in this account where scientific consensus galvanises legal action that this temporal gap between foreseeability of harm and international responses necessarily narrows. And thus this sort of progressive account risks closing down precisely this temporal gap that we need to prise open for liability under the no harm rule to provide for a limited remedy. The second way in which I think this progressive narrative underpinning international law risks closing down this ambition gap between what constitutes due diligence or the conduct that can be expected of a good functioning government and what was actually done by the international community. So more than 30 years after international negotiations on climate change started, I think it's starkly evident how completely inadequate the international response has been to address the problem that they purport to address. The fact that half of all emissions that are currently in the atmosphere were emitted in the last 30 years, so precisely in the period when international law was engaged in addressing the problem of climate change, demonstrates the inadequacy of these responses. But the point I'm trying to show is that this narrative that international law tells of progressively increasing ambition on climate change over time, whilst it acknowledges that there's a greater need for ambition in 2023, for example, than 1992, also implicitly suggests that the level of ambition that was exercised in 1992 or 1997 of Kyoto was adequate to the threat that was applicable at that time. So that is, it assumes that the obligations required by the international legal treaties of the past 30 years met the standard of conduct that can be expected of a good functioning government, applicable at that time. Or to put it another way, it would risk undercutting international law's authority, which is premised on the underlying promise of progress, to say, as I think a sober analysis of the facts would demand that we do, that the legal obligations imposed by climate treaties that were almost universally agreed to were scandalously inadequate in light of what the science demanded even in 1992, let alone 2015. So I hope this discussion has highlighted two of the ways in which I think these accounts of progress in and through law risk minimising the remedies that might be provided by this no harm rule. Thus, I suggest that not only do we need to keep pushing against accounts of how international law is underpinned by narratives of progress and how they risk closing down these temporal and ambition gaps that need to be held open, but more broadly that the climate crisis might be better seen as a catalyst for interrogating the way in which progress narratives structure international legal counts and push us to much more critically rethink the relationship between law, progress and temporality. And finally, in the last part of this talk, I want to highlight that it's worth recalling that international law is actually very well equipped to provide reparations to certain types of harm that occur to certain type of people. And I put quotation marks around people very deliberately. Over the past 30 years, there's been the expansion of a dense network of multilateral and bilateral investment treaties and investor-state dispute resolution mechanisms that are operating to protect investor expectations through international arbitration. And there's growing awareness that there are real risks that investment treaties could pose a barrier to the rapid transition away from fossil fuels and increase the cost of this energy transition. There are now several examples of countries being sued by energy companies for their decarbonisation policies. So, for example, in 2021, 2 German companies, Uniper and RWE, brought claims against the Dutch government under the Energy Charter Treaty, seeking compensation because the Dutch Coal Prohibition Act would prevent coal-fired power stations owned by those companies from operating after 2020. And these cases are pending. But last year, as this headline shows, the UK company Rockhopper Exploration was awarded damages of £210 million, against Italy because the Italian government had imposed a ban on oil and gas projects within 12 nautical miles of the Italian coast, thereby impacting on the company's 2014 licence to drill for oil. And this judgment has obviously been seized upon by climate campaigners to highlight that there should be a mass withdrawal from the Energy Charter Treaty, and there's increased pressure building up for that to indeed occur. But I think it's important to sort of sit with this judgment a little bit more deeply. So although in the judgment the arbitrators affirmed that a host state has the power to amend its legislation due to environmental or climate concerns, the state's sovereign powers to regulate the fossil fuel industry, has the sovereign power to regulate the fossil fuel industry, that is no barrier to the company then obtaining a right to compensation for any negative consequences it might suffer as a result. And so the tribunal provided Rockhopper compensation for this supposed expropriation, even though the interests that Rockhopper held under Italian law did not even amount to a property right. The right it held was not actually a concession right, but rather a mere right to a concession, that is, a preliminary right to a contract. Moreover, in quantifying the amount of damages that should be awarded to Rockhopper, the tribunal did not adopt a sunk costs approach based on the costs that had been incurred by Rockhopper, which would have been only €2 million. The tribunal also did not adopt a market-based approach to determining compensation based on the value that Rockhopper had paid to acquire the investment, which would have been about $36 million. Instead, they adopted an approach to quantifying compensation that was based on the accounting approach of discounted cash flow evaluation, or DCF. That is, based on the asset's future profitability, and thereby they came up with this $165 million figure. As Tony Marshall has argued, this approach is premised on the assumption that the claimant has a right to the future profits that happen to be projected at the valuation date, and therefore to compensation from their loss. He suggests that such a right is dubious in any sector of the economy. However, he argues, and I quote, that such a right to future profits of the fossil fuel industry is even more questionable in the context of climate emergency, given the pressing need to adopt regulations to transition to cleaner sources of energy. So the jarring disconnect between how international law protects, as a form of property right, fossil fuel investors' future expectation of profit, even in the face of the climate crisis, and international law's failure to provide a remedy for historical emissions is shocking. However, it's perhaps less surprising if we recall the historical origins of the no-harm rule in international environmental law. So the rule was formulated in the famous Trail Smelter arbitration between the US and Canada in 1941. In her book Die postkolonische Konstellation natürliche Ressourcen und das Völkerrecht der Moderne, so the post-colonial constellation, natural resources and modern public international law, Sigrid Boysen describes this arbitration as a tragedy rather than a foundational moment for environmental protection or international environmental law's original sin. The case concerned pollution from a Canadian smelter plant in British Columbia that was harming the crops of US farmers on the other side of the border. So rather than addressing this as a domestic tort between two property owners, the US and Canadian governments made the choice to treat this as an international dispute to be settled by arbitration, with the respective governments stepping in for the two parties. By selecting US nuisance law as the applicable law, the tribunal effectively internationalised the domestic principles of the tort of nuisance, which protects the property owner from any substantial or unreasonable interference with their use and enjoyment of their land. So what I think examining the limitations of the no harm rule to provide a remedy for historical omissions, alongside the highly problematic effectiveness of international investment law, makes glaringly visible is how certain actions are recognised by international law as an injury to the use or enjoyment of property rights and thus deserving of a remedy, and others are not. The future expectations of investors to profits based on a preliminary right to a contract is granted the protection of property even in the face of the climate crisis, even though that exercise of that right impels future possibilities of life on this planet. In contrast, the damage caused by the appropriation of atmospheric space and the devastating damage inflicted by climate change are not treated as damages to the use or enjoyment of property, nor is the expectation of a just and livable future treated as an expectation that gives rise to the protections of property. This is, I suggest, the central struggle at the heart of the climate crisis, between how law protects and indeed constitutes the value or lack thereof of certain types of interests and different types of future expectations, and how these inequalities hinge upon or are structured by legal understandings of property. So the stakes of this struggle are huge. If jurisdictions around the world seriously committed to the type of regulatory action necessary to limit warming to 2 degrees Celsius, let alone 1.5 degrees Celsius, by some estimates, $4 trillion worth of fossil fuel assets could become stranded assets. That is, assets in which investments have been made that will no longer earn an economic return prior to their anticipated economic end of life. And so recent analysis has sort of shown, like headlines last week, that the 5 major oil companies made $200 billion in profit in the last year alone. They've been making $2.8 billion in profits daily over the last 50 years. But in concluding, I want to suggest that the disconnect between what harms are treated by the law as harms to the use and enjoyment of property and which aren't highlights at the international level, just as Cheryl Harris brilliantly showed 3 decades ago at the domestic level, that whiteness is property. That is, as she argues, and I quote, that rights in property are contingent on, intertwined with and conflated with race. There is, she argues, an entangled relationship between race and property, and due to this relationship, historical forms of domination have evolved to reproduce subordination in the present. So in conclusion, I suggest that this examination of the way in which international legal principles presents barriers to historical responsibilities for the unjust precarities of climate change in the present highlights that struggles for reparative climate justice and decolonising international law need to contest how notions of progress and future expectations, race and property have been constructed in mutually co-constituting ways, and how this dynamic both denies remedies for historical injustice and forecloses certain futures. This conclusion might therefore also additionally prompt us to reverse the initial problem we started with. Rather than asking how international law might contribute to climate reparations, to instead acknowledge how the broader transformations that are necessary to enable climate reparations, namely a radical reconfiguration of how law constitutes property and thus value, also lays the groundwork for a more just and sustainable international legal relations. As Tendai Chimi has argued in our report, and I quote, reparations which entail equitable international economic, political and legal frameworks can therefore be understood also as a precondition for reorientating the global legal order away from ecological crisis. Thank you.
Can everyone hear me? Good, great, awesome. Thank you, Dr. Dehm, Julia. It was so great to hear you speak on this really exciting talk that I was really, really pleased and pleasantly surprised to be able to respond to. You know, it's a monumental task to follow you up. I feel like listening to me speak after Julia is like having to watch football after seeing Rihanna's Super Bowl halftime show. It's not going to compare, but I'm so happy that Dr. Kons has given me this opportunity, and I'm happy that you all can't change the channel to something more interesting. This is actually not the first time that I've had the honor to engage with Julia's scholarship. As Jason mentioned, prior to my current position at the Rapoport Center, I was the research and advocacy advisor to Professor Tendai Achume, who was the 4th United Nations Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. And if you're ever need to buy time for yourself, just say the full name of a UN Special Rapporteur's title, and you will save yourself 30 seconds. So in that capacity, and alongside the Special Rapporteur's exceptional human rights officers based in Geneva, I supported Professor Achume in researching and drafting this report that Julia mentioned a few times in her talk. And the report went through several iterations, including a few that occurred after I had moved to the Rapoport Center. But Julia was present from the very initialization of this report. She was at expert consultations. And I think if you look to the footnotes of that report, you can really see the foundational academic and scholarly impact that her work had on the outcome. And as you're looking at footnotes, please don't tell me if there are any typos, because I won't be able to bear it. But that was all that to say that I think that it is really important for the interdisciplinary audience assembled here today for me to speak in my capacity as someone involved in advocacy and research in international human rights and international law, to contextualize several of Julia's really key points and point out how eminently useful they are to practitioners, academics, and advocates. And I really think the two bookends of that list are the most important people in the international human rights system, and I think they're ones that are really especially benefiting from Julia's scholarship. So let me start by saying that the harms of climate change and ecological devastation have already been really powerfully articulated by the communities at the front lines of these environmental challenges. The communities most impacted by anthropogenic climate change have also been the ones raising the alarm for decades that our current status quo is completely unsustainable. And so I think the value of Julia's scholarship is not necessarily raising the alarm, but giving advocates, practitioners, and activists tools to make cases to legal decision makers, to political leaders, that the status quo truly is unsustainable, and we need decolonial and reparative justice in order to achieve a world that isn't facing crisis. So I think the first avenue through which you can see this really powerful intervention is Julia's consideration of responsibility. And as any law students know, responsibility, liability, all of these kind of strange concepts are so malleable in the hands of motivated lawyers to obfuscate, to hide the ball, essentially, in terms of compensation and equitable fairness in terms of legal outcomes. And so I think that, as Julia identifies, it's really important to recognize that international legal principles have also been constructed in ways that allow consistent historical evasion of responsibility. And they've been constructed that way because, as Anthony Angie points out, international law was created and structured to allow powerful nations, powerful entities to do so. But in a kind of international advocacy perspective, because human rights law is constantly being contested, not just by lawyers, but by the people who are presumably protected by human rights law, I think not only legal argumentation, but moral, political, and ethical appeals to human rights prove especially powerful. And so one of the great contributions of Julia's work, in my opinion, has been how she's contextualized all of this data about historical responsibility in ways that cuts through kind of the traditional obfuscation of contemporary harm and contemporary responsibility to point out the historical connections between greenhouse gas emissions and the industrialization that was driven by colonialism and the transatlantic slave trade. Second, I want to highlight how Julia's work is so powerful in its critical approach to international legal doctrines and systems, and particularly international economic law, right? So we kind of sometimes have to break through this veneer of neutrality in some forms of international law in which they say, oh, all of that other stuff is political, but the trade law, that's just capitalism, right? And capitalism is just your state of being. And I think it's really important that we have international legal scholars like Julia who are challenging international economic law and other regimes, even progressive, quote unquote, legal regimes like climate change law, to show how they reify neocolonial relationships and contemporary forms of structural marginalization. So I think Julia stands among this great tradition of critical legal scholars and those scholars in the third world approaches to international law in deconstructing how these structures of economic law, of political decision-making, continue to produce the same effects and the same outcomes that they were designed to produce. And I think pulling away the curtain, showing the person behind the mask, so to speak, of international law is a really vital political and scholarly project, and one that I think Julia has done really vibrantly well. And then finally, I kind of want to spend the last portion of my response really talking about what I think is a really interesting provocation right at the end of Julia's talk, to link in the racialization of international law to what's currently happening in the climate change space and elsewhere. So when Julia was talking about evasion, I was taken back to the summer of 2020. And as you know, in May 2020, George Floyd was murdered in Minneapolis, Minnesota, sparking in the midst of the COVID pandemic this transnational uprising against racial injustice and police brutality. What you may not have known is that the United Nations was urgently considering this problem, and at the direction of states in the African group of countries, had actually convened an urgent debate in the Human Rights Council, trying to unpack and untangle what needed to be done to resolve this urgent human rights crisis happening in the United States. And as Professor Achume and Sajal Parmar have argued, as well as others, this was a really kind of like watershed moment in international human rights law, because very rarely have countries like the United States been treated like they were human rights abusers, at least not in these halls of power surrounding the Human Rights Council. And the response by the United States and several other nations who were kind of aligned ideologically with the United States was to essentially evade responsibility for the specific acts of racial injustice that were occurring in the United States. They were acknowledging that racism was a horrible scourge, but no one nation should be singled out. And instead of convening a commission of inquiry to specifically investigate what was happening in the United States around racial injustice, the Western European and others group, as well as the United States, all kind of agreed that it was a global problem that needed a global solution. And in this evasion of specific historicized responsibility for racial injustice, I think really clearly mirrors what we see happening in some of the neoliberal engagements around climate change, right? So rather than just saying, oh, you know, there's specific historical responsibility that needs reparations, there's kind of an obfuscation, an evasion, an appeal to sort of solidarity, but a solidarity that lacks teeth. And then finally, I wanted to kind of provoke the conversation a little bit more by talking about racialization in terms of migration. So it's not something that I think Julia kind of has thought through in this piece, but I think, of course, climate migration is going to be one of the next great frontiers, and already one of the next great frontiers that people are having to grapple with in the international human rights and humanitarian law fora. And I think that the reason I bring it up is because I think that space and place are so important to understanding environmental harm and the mobility of people to evade climate change and ecological disaster. So Professor Achume in 2021 wrote a piece which called Racial Borders, and she actually directly invokes the idea of whiteness as property that Julia mentioned at the end of her talk. And Professor Achume says, in relation to the racialized notions of citizenship, that describing first world citizenship as white property infuses the insights of Ayelet Shachar, citizenship as property, with those of Cheryl Harris, whiteness as property, to call attention to the embeddedness of white property interests in the most fundamental regime of rights allocation in the liberal political order, the nation state. If indeed first world citizenship is predominantly white property, migration governance regimes that allocate mobility and incorporation privileges based on first world passport nationality play a significant role in maintaining and protecting the racialized transmission of first world national wealth. And so I think when we are considering not just mitigation and adaptation, but loss and damage, we also have to consider that the harms of climate change and ecological disaster have also meant the mass movements of millions of people. And for many of them, they've met violence, discrimination, and marginalization as they attempt to pass these national borders into the quote-unquote first world. And for many, many more, they end up in the global south, because actually the bulk of the burden for handling climate change-fueled migration and conflict-fueled migration is not borne by the global north, but by the global south. And so in Professor Achume's piece, in her report, she introduces this concept of racial sacrifice zones. So sacrifice zones have been kind of an idea of ecological harm for a long time, dating back to the testing of nuclear bombs in the Cold War. But Professor Achume argues that both in the global north and in vast swaths of the global south, we've essentially set up global sacrifice zones. And I would argue one of the main tools for maintaining these sacrifice zones are violent, militarized mobility regimes that ensure that whiteness not only is property, but that whiteness is the mobility and the ability to seek safety in the face of oncoming harm. So thank you so much, Julia. As you can tell, it's been really great engaging and interacting with your work and been very useful for my own edification and development. So thank you so much.
So we have plenty of time for Q&As, but I'm going to ask anybody who's interested in asking a question to use the microphone, which is over here. I believe so all this can be captured.
Ariel Dulitsky, I teach international human rights law. If you look at environmental justice, international litigation, climate change, you will see Dulitsky associated with the Inter-American Commission on Human Rights rejecting the first climate change complaint filed with the Inter-American Commission, where we said there's no causation. And I signed that letter. So my question is, we started the event acknowledging that we are occupying traditional land here 10 years ago. So Karen wrote the book on the elusive promise of international law and indigenous right. Are we going to be in 20 years starting with an acknowledgement that there was people here who disappeared because of climate change and the elusive promise of international law was not present, and everybody was writing about reconstructing international law today. So should we keep trying to approach with a legal reconstruction of international law, or this is a project that will fail and we need to engage in other type of political organizations or things like that, that does not repeat the same mistake, that at the end of the day, law could produce some changes, but always will go marginal, but never be enough to change the system at its core.
Thanks, Ariel, for a really difficult question to open things up. But I think that's precisely the challenge that so many of us, working in this space sort of feel, and how we're sort of torn between these different sort of registers as well. Like the piece, the chapter with Sarah Riley Case that I was referring to a couple of times, I think has this sort of split approach. That first it's sort of incredibly doctrinal and tries to say this is how we could use law, and then sort of steps away and outside law and does an imminent critique of precisely what the limitations are. And I think we need to keep doing both those things. But that said, I do think maybe one of the values of reparations as a framework is that I think of it much more as a political framework or a political settlement that is about a negotiated agreement that takes into account a much broader process than the questions that liability for harm in this strictly legal, is there causation, was there foreseeability, was there knowledge, would allow us to do. And so I think there's a lot more thinking to be thought about what sort of broader political processes outside of those strict legal justice remedies that are necessary. I feel like at the moment there's a lot of energy being invested in this ICJ case, and I think it's going to deliver much less than what people hope from it. I think it'll probably give us some positive pronouncements on the law, very little in terms of any concrete action coming out of it. In that way, I'm much more optimistic about some of the sort of more transnational or domestic tort cases, which might actually deliver financial compensation according to those criteria. But I do think it's that sort of, that we do need to be thinking beyond the law, and I do think we need to be thinking about reparations as a political rather than a legal project, and as a key part of having those sort of conversations. So there's part answer, I think, to your question. Thank you. Any other questions, comments?
Hi. Thank you so much for coming. My name is Kenna, and I work with the Rapoport Center. I'm a third-year law student here. I was wondering if you could talk a little bit. I know some about the ability of individuals or groups in the United States to bring lawsuits on behalf of themselves or their communities for environmental harms. I also know that's becoming increasingly difficult with limitations on citizen suits and standing. But I don't know very much, and would love if you could speak to the role of individuals on a sort of a personal level or representing their community in the international space to bring claims, and what space those people can hold it in the advocacy.
Yeah, great. Thanks. I think there's people better equipped than me to answer that question, like Ariel, for example. But like the international law is the law between states. So at like the International Court of Justice, for example, it is only states who can bring claims against one another. So some of those tribunals, you can't have individuals. There are other human rights mechanisms where individuals can bring complaints. So we recently had the Human Rights Committee do its first communication on climate change, and it concerned Australia, where I'm from, and they did find that Australia was in breach of human rights obligations because of its failure to take mitigation action, which was leading to damage to the Torres Strait Islands, which are a group of islands off the coast of Queensland, and had an impact on the Torres Strait Islanders, the Indigenous inhabitants of those areas. So the committee found breaches of the right to private family life and the right to culture. They did not controversially find that there was a breach of the right to life, even though some of the members of the committee in their separate opinions said that they would have found that there was a breach of the right of life. The committee basically said, if this continues, there will be a breach of the right to life, but there's still time to take intervening adaptation action. And But I think what is also really striking about that decision is that the petitioners had asked the committee to consider Australia's obligations, that Australia had breached human rights because of its failure to take proper mitigation action. And there they pointed particularly to the fact that Australia is one of the largest exporters of fossil fuels in the world. We're one of the largest coal exporters and one of the largest exporters of natural gas. That did not come into the committee's reasoning at all. Instead, the focus of the committee was on the failure to take adaptation actions. It left the pointy question of mitigation entirely to the side and focused on adaptation. And I'm really concerned about how this operates, because in a German case that I actually haven't read, but I've just seen a summary of, it was about a German constitutional court case where they made arguments about the rights of future generations, that Germany needed to have more ambitious climate action on behalf of so-called future generations. And there, the Constitutional Court agreed that Germany needed to do more, but said it was just focusing on future generations of Germans, not future generations around the world, because the court could not impact on how future generations in Bangladesh were to experience climate change, because the German government had no control over what measures the Bangladeshi government took to prepare for and adapt to climate change. And so I think we see there, again, precisely that dynamic that I was sort of trying to indicate in the loss and damage space, that we're sort of seeing in this split between human rights saying responsibility for adaptation or failure to adapt rather than for mitigation, that it's those countries who are not doing enough to adapt that are going to be found in breach of their human rights obligations, and the mitigation question getting pushed aside, and then precisely that responsibilisation of those who are vulnerable, saying, well, your government should have done more to prepare for these disasters. This disaster wouldn't have been as bad had you put more disaster risk response mechanisms, for example, in place. So we are seeing, these sort of avenues. We have these petitions to international tribunals, but also lots of frustrations in that process. So famously too, the Committee on the Rights of the Child heard a petition, Greta Thunberg, as well as other youth activists around the world. The committee said some really useful things jurisprudentially about climate change as a child rights issue, but refused to actually take up jurisdiction over the case, saying you haven't yet exhausted all domestic remedies. So it's always a bit of a there are avenues, and I think lawyers are becoming really creative about how we utilise those avenues, but I think we also need to be really wary that through those mechanisms we keep pointing responsibility to where it needs to be placed and not allowing responsibility to get displaced as well.
Hi. But a lot of land back and even common property ownership issues are often precluded by the systems of settler colonial property we have in place. And I was wondering if you had any thoughts, or if international forums have been used in terms of addressing property systems, reforming property systems.
Again, I think Karen might almost be a better place to answer this than I am. There's certainly been a lot of discussion in the inter-American human rights system about how the right to property has then been mobilised by Indigenous communities as a way of asserting rights to land and then rights to culture. And so you have, quite different, pushing back at the idea of property as just an individual right, to recognise property as a collective right impinged with ideas of cultural continuity, cultural heritage, for example. So you have contestations about, what property is and what property means in those sort of contexts. But, yeah. And certainly, like, there have been, examples where, rights have been granted. But, challenges to, I think, the extent to which granting land actually involves granting authority and control over how you might use that land as well, I think becomes some of the challenges. So, for example, in my previous work, I looked at a carbon offset scheme, so forest carbon offsets, a scheme called Reducing Emissions from Deforestation and Forest Degradation. And in that context, I looked at how Indigenous communities were using human rights tools to assert rights to land, and sort of through rights of free, prior, and informed consent, worried that these sort of carbon offset mechanisms would lead to a land grab of these areas, forested areas in the global south. And there I've argued that even in some cases you might see protection of the rights to the land, but the question of how that right is controlled and used is determined by these sort of transnational processes of carbon offsets, that they can only be used in accordance with particular carbon contracts, for example. So I think, again, when we're thinking about land back, we need to be thinking broadly too about, land, but also what is the forms of economic self-determination that having land can provide for communities, and that requires a much broader thing sometimes than just property rights over that land. So thinking about that as a broad, holistic question, if that makes sense.
Thanks, Julia. That was really great. It's so nice to have you back here.
So lovely to be back.
I have a hypothetical.
Yeah.
And I think it's got to do a little bit between the way that rights and reparations can be disarticulated in your talk. So the Italian coast, what are they called? Rock hoppers.
Yeah.
So the tribunal can work out, can make a kind of actuarial calculation on future value and award them. The German court, let's say it could say we need to give reparations for future generations based on current harm, which is already a very weird temporality. What calculations could they use? So, I mean, we know they know how to calculate future, reparations for loss of income to companies. But I mean, what would be how would you calculate, put a number on?
Yeah.
What future generations are going to lose to climate change?
Yeah. Yeah, so just a quick clarification. In the German case, they weren't asking for reparations in behalf of future generations, but they were saying the government had to have a more ambitious climate policy, so it had to have a more ambitious target. So it was really about pushing, that overall policy to be different. But I'll take your question about, how do we even quantify this? So a couple of years ago, I think it was Nature or one of those journals, did a quantification of what they call natural capital and ecosystem services. So how much is provided by the natural world for free, basically, in terms of services if we quantify it. And there's a long project, that I can date back 50 years or so of trying to inscribe natural capital or ecosystem services in economic terms, and a long line of critiques of talking about how this is really reductionist coming from anthropologists and geographers. But I think the fascinating thing there is that the quantification that they came up with is in excess of global GDP. And so in a way it becomes a demand of something that could never be paid back. And so my colleague at the IAS, Elisa Ballestoni, the other day gave a talk where she was sort of saying that maybe there is some value, even though it's so horribly reductionist, in quantifying these sort of harms in order to show precisely that it is a debt that it can't be paid, and sort of analogise to the feminist campaign in the 1970s of wages for housework, which was never a campaign to get paid for housework, which we know has happened, through the outsourcing of housework to precarious and racialised women in most cases, but rather a campaign to say we need to restructure our relations so fundamentally, and that this is just an indication of why. So it's a demand that actually pushes a much broader political agenda. So I found that quite a provocative argument that she was sort of making, that yes, the quantification is quite reductive, but it sort of pushes us to think this actually can't be paid, and therefore our accounting systems can't compute it in that sort of way, but it's rather saying therefore we need to reorganise our relationships with the natural world really fundamentally in a different, so making that political claim then instead.
There are no other questions? In that case, maybe you all join me in thanking Dr. Dehm.